And you want to check.
This is a 126-page judgment. I asked the Chief Justice whether I should read the entire judgment. He said, please no. And so I'm just reading a few selected passages. All right. On the perception of the capability of drivers on the road, the comedian George Carlin made the humorous observation to the effect, have you ever noticed that anybody driving slower than you is an idiot? And anyone going faster than you is a maniac? Concerns about road safety are often shaped by individual biases without the opinion being founded on any empirical data. It is easy to overlook the full spectrum of factors that contribute to road safety. In this context, the pivotal legal issue that this constitution bench of 5 judges has to decide is whether, under the existing legal framework of the Motor Vehicles Act and the Central Motor Vehicle Rules, a person holding a license for a light motor vehicle class can drive a transport vehicle without a specific endorsement, provided the gross vehicle weight of the vehicle does not exceed 7,500 kgs. Besides road safety, the livelihood concern of a large number of drivers of transport vehicle in India also requires an answer from the bench. In this judgment, let us name our driver Sri, who is a transport vehicle driver. As can be appreciated, Sri spends maximum hours behind the driving wheels and is arguably the most experienced one amongst the Indian drivers, carrying goods and people from destination A to B and so on. It is true that Mukund Divangan did not analyze the provisions that distinguish transport and non-transport vehicles, as noted in the reference orders. The statutory scheme of MV motor vehicle is more nuanced than the simple weight-based distinction made in the said judgment. Moreover, the court failed to notice section 31.2 and 31.3, which specifies transport and non-transport vehicles. However, the judgment gave due consideration to the important statutory provisions. We have carefully looked at the relevant and the wide-ranging provisions in our analysis in this decision. A harmonious interpretation, as we have explained earlier, would lead us to the same conclusion, but fortified with some additional reasoning based on the consideration of all the relevant provisions. The overlooked provisions would not, in our considered opinion, alter the eventual pronouncement. Importantly, we do not notice any glaring error or omission that would alter the outcome of the case. Road safety is a serious public issue globally. It is crucial to mention that in India, over 1.7 lakh persons were killed in road accidents in 2023. The cause of such accidents are diverse, and the assumption that they stem from drivers operating light transport vehicle with an LMV license are unsubstantiated. Factors contributing to road accidents include careless driving, speeding, poor road design, and failure to adhere to traffic laws. Other significant contributions are mobile phone users, fatigue, and non-compliance with seatbelt or helmet regulations. Driving a motor vehicle is a complex task requiring both practical skills and theoretical knowledge. Safe driving involves not only technical vehicle control, but also proficiency in various road conditions, including managing speed, turns, spatial awareness relative to other vehicles. Additionally, handling road gradients demands skill, particularly with brakes and maneuvering. Effective driving requires awareness of road signs, adherence to traffic rules, and a focus on the road free from distraction. The core skills expected of all drivers apply universally, regardless of whether the vehicle falls into transport or non-transport category. As discussed earlier in this judgment, the definition of LMV under Section 221 of the Motor Vehicle Act explicitly provides what a transport vehicle means. This court must ensure that neither provisions, i.e. the definition under Section 221 or the second part of Section 3.1, which concerns the necessity for a driving license for a transport vehicle, is reduced to a dead letter of law. Therefore, the emphasis on transport vehicle in the licensing scheme has to be understood only in the context of medium and heavy vehicles. This harmonious reading also aligns with the objective of the 1994 amendment in section 10(2) to simplify the licensing procedure. The above interpretation also does not defeat the broader twin objective of the Motor Vehicles Act, road safety and ensuring timely compensation and relief for victims of road accident. The aspect of road safety is earlier discussed at length. An authority pronouncement by this court would prevent insurance company from taking a technical plea to defeat a legitimate claim for compensation involving an insured vehicle weighing below 7,500 kgs driven by a person holding a driving license of a light motor vehicle class. In an era where autonomous or driverless vehicles are no longer tales of science fiction and app-based passenger platforms are a modern reality, the licensing regime cannot remain static. The amendments that have been carried out by the Indian legislature may not have dealt with all the possible concerns. As we are informed by the learned Attorney General that a legislative exercise is underway, we hope that a comprehensive amendment to address the statutory lacunas will be made with necessary corrective measures. Then we have to flag one concern. The legislature, through the 1994 amendment in section 10(2)(e), in order to introduce transport vehicle as a separate class, could not have intended to merge light motor vehicle, which continued as a distinct class, along with medium and heavy vehicles into a single class. Else, it would have given rise to a situation in which Sri, our hypothetical character, wanting to participate in a cycling event, is put through the rigorous training relevant only for multi-sports like triathlon, which requires a much higher degree of endurance and athleticism. The efforts, therefore, should be to ensure that the statute remains practical and workable. Now, harking back to the primary issue and noticing that the core driving skills, as enunciated in the earlier paragraphs, expected to be mastered by all drivers are universal, regardless of whether the vehicle falls into the transport or non-transport category. It is the considered opinion of this court that if gross vehicle weight is within 7,500 kgs, the quintessential common man's driver Sri with LMV license can also drive a transport vehicle. We are able to reach such a conclusion as none of the parties in this case has produced any empirical data to demonstrate that LMV driving license holders driving a transport vehicle is a significant cause for road accidents in India. The additional eligibility criteria as specified in the Motor Vehicles Act and the rules as discussed in this judgment will apply only to such vehicle, medium goods vehicle, medium passenger vehicle, heavy goods vehicle, and heavy passenger vehicle whose gross weight exceeds 7,500 kgs. Our present interpretation on how the licensing regime is to operate for drivers under the statutory scheme is unlikely to compromise the road safety concerns. This will also effectively address the livelihood issues for drivers operating transport vehicles who clock maximum hours behind the wheels in legally operating transport vehicles below 7,500 kg with their LMV driving license. Perforce, Sri must drive responsibly and should have no occasion to be called either a maniac or an idiot, as mentioned in the first paragraph, while he is behind the wheels. Such harmonious interpretation will substantially address the vexed question of law before this court. Our conclusion following the above discussion are as under. A driver holding a license for light motor vehicle class under section 10(2)(d) for vehicles with gross vehicle weight under 7,500 kg is permitted to operate a transport vehicle without needing additional authorization under section 10(2)(e) of the MV Act, specifically for transport vehicle class. For licensing purpose, LMVs and transport vehicles are not entirely separate classes. An overlap exists between the two. The special eligibility requirement will, however, continue to apply for inter alia, e-carts, e-rickshaws, and vehicles carrying hazardous goods. The second part of section 3(1), which emphasizes the necessity of a specific requirement to drive transport vehicle, does not supersede the definition of LMV provided in section 221 of the Motor Vehicles Act. The additional eligibility criteria specified in the MV Act and the MV rules generally for driving transport vehicles would apply only to those intending to operate vehicles with gross vehicle weight exceeding 7,500 kgs, i.e. medium goods vehicle, medium passenger vehicle, heavy goods vehicle, and heavy passenger vehicles. The decision in Mukund Devangan is upheld, but for reasons as explained by us in this judgment. In the absence of any obtrusive omission, the decision is not per incurium, even if certain provisions of the MB Act and MB rules were not considered in the said judgment. The reference is answered in the above terms. The registry is directed to list the matters before the appropriate bench after obtaining direction from the Honorable Chief Justice.
Obliged, Your Honor.
Deeply obliged.